Hello student, I am Assistant Professor Yeshwan Bora from LG School of Law, and today we'll be discussing about the topic of the Evidence Act, which is definition and may presume, shall presume and conclusive proof. So first we'll be dealing about the section 1, and section 1 talks about the short title, extent and commencement of the Evidence Act. Now as you see, first section, it says that this act may be called the Indian Evidence Act 1872, and it extends to the whole of India including Jammu and Kashmir and applies to all the judicial proceedings in or before any court. Earlier, before, when there was existence, the 370 was there, article 370 was there. At that time it was not applicable in the state of Jammu and Kashmir, but after the removal of article 370, it is indirectly, you can say, just from after removal, it is applicable to the state of Jammu and Kashmir. Now moving further, you see that it came into force in the month of September 1872, and it was enacted, you can say, in the month of March 1872. Now moving further, you see Evidence Act is not applicable. This further definition, it will say that where the Evidence Act is not applicable, I've broken the broken the definition in two parts. So in the second part, you will see where the Evidences Act is not applicable. In first part, you have seen it is applicable to all the judicial proceedings, but now where it is not applicable. So the first is court martial proceedings under Army, Navy, and Indian Air Force Act, because the court martial proceedings will be governed by this act itself. What act? Army Act, Navy Act, and Indian Air Force Act. Now, second category is the affidavits. Affidavits presented to any court or officer will not be governed by the Indian Evidence Act, or you can say that Indian Evidence Act will not be applicable to the affidavits. Why they are not? Why Indian evidence is not applicable? Because they have their own provisions for filing the affidavits, and affidavits which are made under, you'll say, in the civil law, order 19 of the CPC, and in the CRPC you will see the section 295, 296, 297, which talks about the affidavits. Now the third category is proceedings before the arbitrator. While proceedings before the arbitrator is not included, or the Evidence Act is not applicable to them, because they are governed by their own act, which is known as Arbitration and Conciliation Act, and again they are not covered under the definition of judicial officer, or you can say the judge. Okay. Now moving further, you see the different definitions. So our first definition is court. So the court includes all the judges and magistrate and all the person authorized to take the evidence except arbitrator, legal except arbitrator. Okay. So now you'll see in our previous definition one that arbitration is, like, I'll go to that slide. You'll see that proceedings before the arbitrator will not be applicable to the evidence shall be not be applicable to the proceedings before the arbitrator. And again, in the definition of court, you will see that arbitrator is not been included. Why they are not included? Because they again governed by their own law, and they are not allowed to follow the strict rules of the Indian Evidence Act. So in this particular definition, you will see court includes all the judges and magistrate, and again all the powers who are authorized to take evidence. Now, what kind of persons that can be? If the court gives orders to the particular person, you will say there are some small cases in which again the sarpanch is having power to take the, or to hear the evidences. Then in that case, the sarpanch is can be that kind of person, and he can be included in that particular person, and if he is authorized by the law to take the evidence. I hope you must have got this particular definition. Now, the second definition is fact. Now, fact means and includes anything, state of thing, relation of thing, capable of being perceived by the senses. Okay. Now, again, I'll read: facts means and includes anything where it is placed, or relation of thing to whom or which thing it belongs, And third, capable of being perceived by the senses, or you can say any mental condition in which any person is conscious. Okay, so now you will see in the definition of facts there are two kinds of facts. One is physical facts and one is psychological facts. And you'll see uh, the third point, which is capable of being perceived by the senses, can be included in the psychological fact. So you see that anything or state of thing, it means about the thing only. Relation of thing, it talks about the relation, that whether the particular thing is belongs to that particular person, or whether that particular object belongs to that person, and it being capable of being perceived by the senses. And the last thing, you'll see that any mental condition in which the person is conscious. The mental condition, why it has been taken as a fact, that why, because what was the mental condition of the person while doing that particular, or you can say while doing that particular act or that particular crime, what was the condition, mental condition of that person. I hope you got have the you must have got the definition of fact. Now moving further, you'll see the definition of relevant. Now, what is relevant? One fact is said to be the relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of the fact. Now, whatever facts which are connected with another fact can be a relevant fact. Now, how these facts will be a relevant fact, that is, or you can say the facts which are mentioned between section 6 to 55 can be deemed or can be termed as the relevant facts. Okay, now the next definition is fact in issue. So the fact in issue, it goes like the expression fact in issue means and includes any facts from which either by itself or in connection with other facts extent of any right, liability, disability asserted or denied, any suit or proceedings necessary follows. Now there can be more than one fact in issue in a trial and are to be proved before the court. In this definition, you'll see that fact which talks about the existence, non-existence, the nature and the extent of any right, liability or disability which is asserted or denied in a suit will be known as the fact in issue. Uh, like I have interpreted definition in this particular manner, that there is a fact, and that fact, particular fact talks about any existence or non-existence or nature or extent of any right, liability or disability. And now this right, existence, non-existence, nature and extent is being asserted or denied in a suit, then that particular fact will be the fact in issue. And also there can be more than one fact and issue in the particular trial. It's not that there will be only one fact and issue, and only in a single trial there can be one fact and issue, but there can be more than one fact and issue in the trial. Now moving further, we'll see the document definition of documents. Now documents means any matter expressed, described upon any substances by means of letter, figures or marks, or by more than one of the means intended to be used, or which may be used for the purpose of recording that particular matter. Now you will see that a document can be anything as in on which, like, it can be a stone if something has been inscripted on the stone, it can be a letter, it can be figures, it can be marks. Okay, and it can be you'll say it can be in the recorded form also, or it can be in the written form also. So all these types of matters you will see will be termed as the documents. Okay, again I'll give you one example, that you while moving on the highway, you see the milestones, which says that and this particular place is this kilometer, x place is this kilometer. These also, this milestone can also be taken as the documentary evidence, or you can say documents. Now moving further towards the definition of evidence. Now evidence includes all statement which the court permits or requires to be made before it by the witness in relation to matters of fact under inquiry. Such statements are called oral evidences. Second point is that all documents including electronic records produced for the inspection of the court, and such documents are be called as documentary evidences. So in the definition of evidences, you will see two definitions have been included. One is given as a oral evidence, one is given as a documentary evidences. So oral evidences says that whatever has been statement has been given by the witnesses in relation to the fact and issue, that will be known as the oral evidences. And documentary evidence, what it says that any document, it includes the electronic records, whether it is recorded somewhere or whether it is a document which talks about the fact and issue, then it will be called as a documentary evidence. I hope you have got the definition of document and documentary evidences. The further the previous definition of document, you can say that it can be, again it can be known as the documentary evidences. You will see that it's not about the written form or any document. It is also about the recording, electronic. It includes the electronic records also. Okay, now moving further, we'll see the definition. These are the three definitions, which is, I think it's very interesting and important. The first is proved. Now the fact is said to be proved when, after considering that matters before it, the court either believes that this particular fact exists, or court says that it considers its existence so probable that a prudent man ought, under the circumstances of the particular case, and act upon the supposition that this particular fact exists. Now, in this particular definition of proved, it says that it talks about the existence of the fact. Okay, if there is a matter before the court, and after the investigation it has been proved that this particular fact is exist in the trial or in the court, then, and the court believes that this particular fact exists. Okay, and again there are some inferences, you can say, and after the investigation it is obvious, or you can say the person can make an inference that this particular fact exists, then this fact will be known as proved. Now to prove the fact, the burden of proof is on the prosecution that yes, this particular fact exists. I hope you must have got the definition of proof. Now moving further to definition of disprove, it is just the you will see the opposite to the definition of proved. It says that a fact is said to be disproved when, after considering the matter before it, the court either believes that it does not exist, or consider its non-existence so probable that the prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Now you will see this particular definition talks about the non-existence of the fact, that this particular fact does not exist. Now the burden of proof is again on whom? It's upon the, you say, the accused, that he has to prove that if the prosecution proves that this particular fact exists, then it's now the burden of proof is on the accused that this particular fact does not exist. Okay, now moving further, the definition of not proved. The definition of not proved, it says that facts which is said to be not proved when it is neither proved nor disproved. It means that the facts which are untouched by in the proceedings, fact which are not taken in the proceedings, will be termed as the facts. Those facts will be termed as not proved. Okay, I hope you must have got the three definition, because three definitions are very according to my point of view, it is very important. Okay, now moving to again a very interesting definition, section 4. It talks about the may presume, shall presume, and conclusive proof. It talks about the presumption. Now, in general term, I'll say that may presume, shall presume, and conclusive proof. May presume is the discretion of the court, and shall presume is the mandatory for the court. Now, we'll see the definition. May presume, it has been said that whenever it is proved by the act that the court may presume a fact, it may either regard such fact as proved, or it unless and until it is disproved, or may call for the proof of it. Now you see that may presume. Okay, now I'll say that in this particular act, you will see that there are some sections which talks about the may presume. Now, in what will be the case in may presume? If there is a term in which is I'll refer the section 113A. You will see that is the section in which it is written that the court may presume. Now, in the case of may presume, the court will think that this particular fact is a proved fact. Okay, it is the discretion of the court until and unless this particular fact has been disproved by the defense, or you can say by the accused. uh, Now it is again, the party cannot compel to presume a fact. Party cannot compel to presume a fact that yes, this fact exists, this fact does not exist. It is the discretion of the court, which the court will presume that the fact, and now it will call for the proof. Now moving further, you will see the definition of uh, may shall presume. Now shall presume, it says that whenever it is directed by this act that the court shall presume the fact, it shall regard such fact as proved until unless it is disproved. Now you see the section 113B, 113B, which talks about the presumption of dowry there. Now in that particular section, if you will see that section, you will see that there is the term shall presume, that the court shall presume. Now in that case, until and unless that particular act or that particular fact is disproved by the party, the court will always presume that particular fact. Okay, I hope you must have got it. Until and unless the other party disprove the fact, okay, that this particular fact does not exist, till then the court will presume that this is the fact, or the fact exists. Now you'll see the in this particular shall presume, the court is bound to presume a fact. Okay, the court is bound, it is mandatory for the court. It's not like that the court is generally doing it, but it is the mandatory for the court to presume that particular fact, that yes, this particular fact exists until and unless the fact is disproved by the other party. Now moving to the conclusive proof. Conclusive proof. Now the conclusive proof, it says that when one fact is declared by this act to be conclusive proof to of another, the court shall on the proof of the fact of one fact regard the other fact as proved, and shall not allow the evidences to be given for the purpose of disproving act. Now, conclusive proof says that once the fact has been proved by this particular act, now the court will say that the court will not consider any further evidences to disprove this particular fact. Why? Because this particular fact has been proved, and there is no need to give the evidences related to the this particular fact. Now these types of facts cannot be disproved by any sort of evidences. Okay, so in that case, sorry, in that case you will see that when there is a conclusive proof, when there is a matter of conclusive proof, the court will say that yes, this fact has been proved and it's done. Now there the court will not consider, or the court will not hear any of the fact and it cannot be disproved by any of the fact. I hope you must have got this. So I'll rest my lecture here only, and I hope you must have got the definitions. Now, again, I'll say that while going through this presentation or any of the presentation, you must keep bare act of that particular subject or the reference book of that particular subject, so that you will come to know about the you say what about the topic or about the sections in a better way and in a correct manner. Otherwise, it will take a lot of effort to get through the sections. So I rest my lecture here. Hope your for your betterment, and take care of yourself. Okay, thank you and bye.